A tense courtroom erupts as confusion deepens over secret phone calls and hidden recordings. The judge's patience thins while Mr. Lee insists he acted only to expose his own lawyer's lies. But when a call reveals something darker, the room descends into chaos, and the judge has heard enough.
Before he makes more statements.
And I did record the call.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because he's interfered.
An attorney about the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes.
Okay, could you please state your name?
Thoroughly.
What is that noise?
Right. Shouldn't you check? I don't feel safe. Why are you just pointing? What?
Don't stop. So
It'll stop at some point.
I feel very safe.
Wow, I know. He's like, you are all over it. All right. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMB against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want it documented for potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's your name?
Mary Rubio, Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorneys. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea, not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Consley agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
He might want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you. Somebody needs to listen to him.
Yes.
Just listen to it together.
Have you heard him? Or
Just now. Prosecutor and I listened to it together.
okay. It's like, all right, I'll recall that momentarily.
And then everyone else gets voted.
Everybody else is holding back. And
Mr. Kennedy. Has Yeah.
okay.
Yep.
So this one we're going last. Right now.
No. This one.
That's
This
fine.
last.
So just
Yep.
hold down.
Yep.
It's between these two. What happened to our?
That was at 2:00. We haven't gotten there yet.
Oh,
I haven't talked to you about those at all yet.
ow. Okay. All right, but this one has one. And then we gotta bring Lee back out. So, who's on this one?
This is 4 witnesses with Miss Tanha and I believe Miss Ackerley.
So, then this is good night.
9 is REVOKED.
How many witnesses on that? One witness? Okay. Get Mr. Burkett in here. We'll handle that one. I'm gonna take a brief break. We'll handle that one, then I'll get Mr. Lee out. Okay,
Thank you, Your Honor.
and deal with Lee.
That's my order then.
All right, court is standing, Larry Lee.
All right.
Good afternoon, Your Honor. Marie Tanhouse, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wear a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry?
Oh, there you
Good
go.
afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was, the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Rubble sent me, as well as Mr. Burgess, and law enforcement as this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No, Your Honor.
Attorney.
By the midpoint, the defense claims a misunderstanding. Lee only wanted truth, not manipulation. But the prosecution insists it's witness tampering, not miscommunication. As the court listens to the damning recording, one decision will change everything.
It's with Mr. Rubble, who's attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Rubble has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me until, and then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time. I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Quasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
Because it would have been unethical for Mr. Burgess to try to say, my client will testify in this other matter.
Of course.
If that, right? That's
Well-
what Mr. Burgess may not have done.
And that may very well be, but Mr. Lee indicates that and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that. But I just wanted
Your Honor,
to make a record. What, could I just finish though?
Let her finish.
Mr. Lee indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. The call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if maybe if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with interrupting.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo is making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quadley, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quadley not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. It has gone to law enforcement now, and we can follow up.
Mr. Rao.
Your Honor, as you know, I'm a defense attorney. I think Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what he's being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how this slipped between the cards, because in over 10 years of practicing, I've never seen something like this, where a victim turns into a defendant during a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Quasny, so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quasny using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this. And it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listen to it already.
Can somebody send it to Ms. Weidling, and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and court listen to the call. I can give my decision.
You have to go back.
To you. I'll handle that coming back out. I I think Miss Atkins on that. So bring me that. Court's going to stand in recess. Everybody can remain seated. Bring. And I got this here. Now I got Kennedy Brown. And got it.
Yeah.
Okay. Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tanhouse, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Get your name, please.
Clearly.
Okay. The issue is in this case that, first of all, we're adjourning the hearing.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the.
Oh.
I'm on the bench, but I'm not doing these.
Okay.
So. Set his preliminary examination July to defendant's request. So my next date is July 22nd, 2025, and that's another 12 p.m. start because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr. Lee has told
and I
me.
understand that.
And Mr. Lee is about jumping
you,
out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr. You might as well stop right now.
I have the text
Because
message.
no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know what how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Thank you.
Thank you, Your Honor.
Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record?
Pardon? I am.
Are you still on the record? You know, I'm not sure who this kid is or what he's capable of or what sort of messages you can get out to other people. But if the court could put a no contact order because somehow I've become a witness in this matter, I'd appreciate that.
A no contact with you?
Yep. I don't want to be contacted by any third parties. I want out of this thing and I want to be done with it. Didn't ask to be here.
I will add that no contact provision in.
Yeah, one of those, Your Honor.
But counsel, why don't you let us know how you really feel? I know. All right. We'll
I
take
think
care of that.
I think the courtroom's been through enough today. Thank you.
It began like any other hearing, routine, procedural, but within minutes, the calm shattered. The judge, visibly on edge, listened as attorneys argued over a mysterious phone call. The defendant, Larry Lee, stood at the center of a storm of his own making. His lawyer was absent, replaced by a substitute who seemed unsure of what she had walked into. Lee's voice trembled with restrained frustration as he claimed he had been forced to act because his own attorney, David Burgess, had lied to him. Lee insisted that Burgess ignored his pleas for a plea bargain and fabricated updates about negotiations with the prosecutor. Determined to expose the truth, Lee took matters into his own hands, recording a phone call that would soon ignite the courtroom. He dialed another attorney, Joseph Arabo, who represented the alleged victim in Lee's case. Lee asked a dangerous question, whether Burgess had reached out to discuss a possible settlement, but the call revealed something far more explosive, an apparent offer not to testify if the victim also remained silent. The courtroom froze. What Lee claimed was proof of ineffective counsel, others saw as an attempt to tamper with a witness. The prosecution called it disturbing. The judge called it interference. And before anyone could breathe, Lee's bond was revoked. Officers led him away as the courtroom buzzed with disbelief. Hours later, after every lawyer had listened to the 2-minute recording, the real meaning of that call came into focus. The judge replayed the conversation in her mind. An unmistakable exchange, a quid pro quo, Lee offering silence for silence. It was the kind of moment that strips away ambiguity. Whatever Lee's intentions, the evidence was clear. The defense fought back, claiming Lee only wanted confirmation that his attorney had failed him. His substitute counsel painted him as desperate, not deceitful, a man betrayed by those sworn to defend him. But the judge saw through it. To her, this was no act of frustration. It was manipulation cloaked in legal jargon, a calculated move to bend justice. Then came the breaking point. When Lee tried to speak again, insisting he had proof that Burgess himself suggested the call was a legal way forward, the judge snapped. Her gavel slammed, her voice rising with controlled fury. You are not going to sit here and disparage that man. I'm not going to believe it, and I'm not going to hear you. The courtroom fell silent. Lee's final attempt to explain dissolved into the echo of his revoked bond. His phone privileges were cut. and a new no-contact order was issued to protect the very attorney he had called. When the gavel fell for the last time, the air was heavy with something more than judgment. It was disappointment. What began as a plea for fairness ended as a lesson in self-destruction. In the end, Larry Lee didn't just lose his freedom, he lost the court's trust, and perhaps the truth itself.